well-fabricated regulatory framework that recognizes these differences?
Well, we start, let me take a step back before I answer that specific question, because that's a very good question. One of the issues that Reggie raised is one that speaks to part of what Steve said earlier, and that's a question of perception of the industry. It is not a monolithic industry, okay? It surprises citizens when I mention to them that we've been fracking to produce oil and gas for many years in the Commonwealth. That there's a distinction between nitrogen fracking and the use of a very limited amount of water in order to introduce the proppant into the seam, because nitrogen doesn't do a very good job of that, versus high volume hydrofracking of the sort that you're seeing in the Marcellus and the Utica formations. And so in answer to the issue of whether you bifurcate, you need to tailor your regulatory framework so that it addresses the issues that are raised by the particular operations. There will inherently be that bifurcation on some issues, okay? But then there are others that are common. For example, the footprint of a traditional nitrogen frac operation, the surface footprint is far smaller than the footprint of a high volume hydrofrac operation, and that needs to be understood. But the industry, to its credit, the association to its credit, embraced the idea that everyone should do a reclamation plan, because back 21 years ago, when that concept was first introduced, it was limited to severed estates. So that unless you were a lessor that was savvy enough to put a reclamation obligation in your lease, there was no protection under state law. And I've got to commend the association. I know there was some give and take within the association for recognizing that that is good practice. Right? On our side, it was a recognition that there is going to be a learning curve when it comes to it. And so what you do is you attempt to put best management practices in place, straw bales, breaks in the roads, and the things that you do, and that the first response of the agency is to assist in improving those practices rather than penalizing if those practices are not effective. So there is some give and take there towards a common goal. Similarly, when you're dealing with water issues, there is a common goal. And I mentioned to the group, I always thought it was kind of interesting when I tell my students, and I'm going to be teaching energy law again this fall, that the framework for the Interstate Oil and Gas Compact in dealing with conservation of the resource is talking about conservation of the oil and gas resource, and fresh water is actually looked at as being a pollutant. But it doesn't matter. As Orwellian as that may sound to somebody who's not familiar with the development of the industry regulation under the IOG, under the Interstate Oil and Gas Compact, you arrive at the same goal. Right? The operator no more wants water in their production well than the citizen wants natural gas liquids or methane in their water supply. So you have a common goal of assuring the mechanical integrity of your well bore and the isolation of your producing zone from pathways where you could have the cross-contamination of aquifers due to past drilling that is not properly plugged or due to natural fracturing within the formation. So we start with that assumption that there is some common ground, and then we look for reasonable ways of protecting the non-target formations while allowing reasonable development of the formation. One of the things that I think, and I was in talking recently, I was on a day-long presentation in Washington that was talking about the development of the hydrofracking industry, that this new method of producing formations that historically were not deemed to be economically or technologically viable. And that is, to a certain extent, the national industry, those that are engaged in the hydrofracking, brought some of this reaction, some of which is not a science-based or a technology-based reaction. They brought some of this on themselves. Okay? When you go in and you exempt yourself from the underground injection control program in 2005, You invite somebody, and then you claim trade secret for chemical, composition. You invite people to say, what are you hiding? And why is it that you want to do this? You also create this perception that, and reality, that in some cases there may not be sufficient regulation, which triggers fracking bans, which triggers a kind of reaction. So one of the things that I was very pleased about in our negotiations is that everybody's recognized transparency is a valuable thing, okay? Because you got nothing to hide. Right? So in Kentucky, you can't claim trade secret on what the chemicals that you're using. In Kentucky, you can on the composition, because that's kind of the magic sauce, that some folks have. In Kentucky, we currently do, and I think we will see maybe some enhancements of that, try to assure the integrity of the bore of any wells that are drilled for the production of oil and gas, including those that are using hydrofracking. Because the UIC program, everybody understands it, right? It's a technical program. It doesn't bring with it value judgments other than the fact that it's not a good idea to contaminate underground sources of drinking water. It has mechanical integrity tests. It raises that level of confidence that if you do what you're supposed to under the program, you're not going to be a problem in terms of contamination of water supply. So I think there was a little bit of, those that were lobbying in 2005 to include that exemption really did the industry in general no favor. Because instead of getting a program that everybody understands, which is technically and scientifically based, you end up with every local government in the process getting, hyperventilating about it.
I introduced a term to this discussion that I want to remove, and it was bifurcation. Actually, that's an improper use of the word, at least as I was addressing it. I think it's a tiered level is more appropriate, that a lower tier and a higher tier are more appropriately applied to lesser at-risk wells versus more higher at-risk wells. So if we can maybe get away from bifurcated, and I introduced it and talk about tiers, I think it's far more appropriate. And so I'm suggesting tiered regulation based on risk and reward.
Well, that's a common feature of RCRA regulations, for example. Where you can take a look at volumes, you can take a look at risk, and you can have regulatory programs that are tailored to that. So that certainly is a reasonable approach.
Let's see if we have any questions from the audience at this point. Yeah, John.
To Tom. Did a 186 meet your test to American shoe shine? If not, what's it going to take to get to that?
That's a really good question. Some of you may be aware, back in the late 70s, I got a pair of shoes from a friend of my brother's, and being the clothes horse that I am, I never would shine them. And Herbie Deskins, who's from Pike County, was then the chair of the Natural Resources Committee, passed me in the halls one time, and he looked at me and said, "FitzGerald, when are you going to shine those shoes?" And I said, "When are you going to pass a good bill?" So it became a joke that became something, that it's been written up in the Courier. So I guess it's gone into the vernacular now. But they've only been shined 5 times in the past 30 years. Now, some people might say, well, that's pretty grim. I view it as hope springing eternal, right? In 1991, we passed the Solid Waste Reform Bill, which took us from one of the worst to one of the best states in the nation in terms of managing garbage. And so that was the first time they got shined after, which had been a long dry spell since 1978. But yes, the 186, I think, was a positive enough accomplishment that I am going to shine one of the shoes. The problem is,
It'll be the left one, by the way.
The problem is, however, AT&T managed to get their deregulation bill through, which I think poses a direct risk to a lot of people in the Commonwealth who will now have less reliable 911 service and and is problematic for a number of other reasons. So I'm going to have to cut the sole off the other shoe. So it's like kind of a mixed bag in terms of, but the other, getting back to Andrew's question, one of the issues where I think we're looking at a tiered approach, but we have the benefit of getting out in front of this issue is water management and wastewater management. And that's a big issue that we are going to have to tackle. There is some redundancy, there are some gaps among the different agencies, and I think it's a legitimate objective for the industry to have one set of rules that are clearly understood and a primary agency contact that you're dealing with. From our standpoint, it's how do you manage water consumption issues, water management issues, water disposal issues, wastewater disposal issues. So that's one that we're, I think, going to be grappling with during this next interim, and would encourage you all to stay close to the process and to give us feedback, because it really does help to focus the discussions and to assure that they are meeting the industry's needs for orderly development and meeting our needs for protecting drinking water supplies, protecting surface and groundwater sources.
And for the benefit of the attendees, Tom just articulated with water management being, I think that was probably the primary issue that Kentucky Resources Council wanted to make sure was on the agenda for the work group. The work group has identified 4 topics that we're going to continue to work through in these coming months: water management, pit closures, and land application. Trying to identify a funding source for the abandoned storage tank program, which we've talked a little bit about today, and the definition bill of stratigraphic wells. So that's sort of the lay of the land. I think that, as we found in the last phase, though, as we work through things, other issues just kind of seem to appear, and if we have the time and we feel like that it's something that has some pressing need, and we take those on. But so, it gets to the question, Bill, from an industry standpoint. I think that, we certainly made a significant number of compromises in this last go-around. But also, as you pointed out, in terms of changes to the deep well statutes and the certainty that goes along with that, what is it that the industry sees as being a priority in this next phase? What would be something that would continue to put into place the regulatory incentives and the certainty for the industry to continue to explore and invest and drill? How do you see that in this next phase?
Well, I certainly don't think we're finished with our work regarding deep wells, and to some significant degree, the stratigraphic test issue plays into that. The release of information relative to stratigraphic tests or something that is going to have to be looked at. As we move forward with additional deep well development, the issue, and there was pushback this time, the old deep well statute, most of you, well, let me step back. Compulsory or forced pooling is something that most of the enlightened or progressive oil and gas producing states have. Kansas hasn't embraced the concept very well, nor has California. But other than that, compulsory or forced pooling exists in most of the states. Now, it is tougher in some states than others. Virginia has a very low threshold, 25% interest in the proposed pooled area, and you can file your application. Ohio set a high threshold at 90%. The deep well statutes, when they were written initially in Kentucky, varied from our typical 51, you had to have more than 50% in Kentucky to file an application for forced pooling. That was changed in the deep well statute in the 60s for deep wells only to 75%. It's an unmanageable number, and my friend Tom is going to jump in here quickly, I suspect, but let me say why it's unmanageable. If I have to put together in a typical vertical deep well non-wildcat situation, 5,000 square foot, it's 5,000 foot square, and then I have to have 75% of the amount of acreage within that before I can file my forced pooling. Two things happen. The industry, the Commonwealth, and up to 74% of the involved landowners or mineral owners who have indicated a willingness and a desire to have their minerals developed in a responsible manner have been excluded from the opportunity because of the 26%. It's a large number, and as I start to lay out units for horizontal wells with long leg laterals going directionally across property lines, it gets to be a bigger issue. Development will be curtailed, in my opinion, significantly if we leave that number at 75%. Those that would claim landowner, mineral owner rights trump the rights of the majority need to recall and remember that there are protective devices built into the compulsory forced pooling statutes. Either the non-participating landowner can be deemed to have leased, can go non-consent, or can write a check. I believe that's a major issue and one that will come back up on the table. We agreed in the benefit of moving the other changes forward to not fight that out this last time because we needed the other deep well changes to move forward with the expiration of the Rogersville.
Tom, any response?
Well, it is an issue that implicates some pretty profound questions regarding the rights of private landowners to be, essentially to be left alone. And it is one that I look forward to the additional discussion on. It's kind of ironic because, when you try to pigeonhole people based on one issue or another issue, I find myself being embraced by Tea Party folks because I don't think that part of the oil and gas industry's business model should be condemning people's property. I have a fundamental problem, and it's not one that is limited to forced pooling, but which extends out to joint tenancy situations. Okay, because in Kentucky, a 1% mineral owner of coal rights, okay, under what I think is some misbegotten case law, can lease that property subject to accounting to the others, and can defeat the intent of 99% of the owners that they don't want the property to be developed. So I understand your point, and it is one that really does bear some careful discussion. On the one hand, you have the ability to develop the resource in the most efficient way. On the other hand, you have a bundle of rights that we have a profound respect for constitutionally, that you're forcing an individual into a business relationship that they do not, for whatever reason, want to be part of. And so there's that element of compulsion there that is a concern.
Would you accept any percentage?
That's a very good question. I philosophically I have
Probably not here.
I have a real problem. What's that? I didn't hear you.
I said probably not here.
That's right.
Accept any percentage. I don't think Tom's going to give that away here.
You're asking me individually, philosophically. I have a problem with compulsory pooling, period. Okay, but as a question of what the policy for the Commonwealth would be, that's not my decision. But I am hopeful that as we go through these additional discussions, there may be some other protections that we can build in for a non-participating owner that would make the concept less onerous. We are dealing with a different resource, and there is, at least in a constitutional sense, because of the rule of capture, We're not dealing with a fixed mineral resource. In that case, I think compulsory pooling has some real constitutional issues.
No surface
Here,
disturbance either.
here you're dealing with, well, yes, possibly, possibly not, you don't know. But you are here dealing with because of the rule of capture, you're dealing with a resource that is not owned theoretically until it is produced. So there are some different issues there constitutionally. And I look forward to us having additional discussion on that. I understand that it becomes more problematic when you are doing horizontal than vertical drilling.
What number do you like, Bill? Excuse me, Tom.
I like 50, greater than 50. Majority rules.
Big, ooh, that's a big number.
We're going to keep the panel going for about another 10 minutes since we got a little bit of a late start. Harry?
Oh, I just wanted to add to that mix, as effective as a title attorney as I'm learning from some of the best, add to that mix the unknowns. The folks you just can't find.
Right. And of course, the question then is, do you require that there be an action to quiet title as the mechanism for addressing that, or do you use, forced pooling with newspaper notice? That's a very good point. But that is, particularly when you have folks who may have a fractional interest, as we know, Eastern Kentucky is famous for property that passes intestate, and you have, rather than through a will, and you have fractional interests that every generation are dividing again, and so that as a practical matter, it becomes that much more difficult to identify and negotiate with multiple landowners. So that's a good point.
Reggie, what about priorities in this next phase? You've laid out some principles, some guiding philosophy, if you would, but any specifics, of the topics we have in front of us, what do you think that this group should be working towards and working on?
Well, I'll just reiterate, we're still running from seismicity when it's an easy issue to address in Kentucky. And what you're hearing here, and what has been educating me on this panel is the meat and potatoes issues of your business. Getting right down to it. It's this panel has done the workforce has done just a really good job of wrestling with real meaty issues. And those meaty issues are getting resolved to the benefit of the industry, to the regulators, and I think to the public, and they're being well resolved. But they're not addressing Steve's issue, and that's something that I think we can do at the same time, and that is to start to demonstrate to the public that is so concerned and may be misinformed that we're not hiding from issues that hit the press every day, that we recognize that they're legitimate issues, and that we're going to at least investigate them, if not actively address them. We can't hide from the fact that there's a great controversy about climate change. Some people would say it's a fact, not a controversy at all. There are a lot of global interests weighing in on it. The public is confused. It's foolish for your industry not to say, hey, it's a legitimate issue, and it's one that we ought to look into, and we ought to at least embrace the concept of figuring out well to wheel what our emissions are that contribute to that issue. I'm not saying we pass a law to regulate it, but that we pass out a message to the people in the state of Kentucky: we're with you, we understand it's an issue, and we're going to do the science that Steve talked about to try to find a position that protects you. And until we stop running away from these issues, and until we stop taking the us versus them mentality, the oil and gas industry is going to be closeted with other industries that they really don't belong with. And so that's how I would proceed.
Yeah, Krista?
So I wasn't exactly clear. You used the word seismicity, but I know that KGS is very helpfully just put out an array, which will start the process of having some baseline data, but absent data, what is it exactly that you would have anyone do with that issue?
Well, the first thing I would do, and I've suggested this to our panel, the first thing I would do is put it up on the agenda, and let's talk about it, and say, all right, what do we know in the state of Kentucky? Secondly, what do we know in surrounding states? We've got some experience now in Ohio, maybe only one actual fracking well, but we've got all kinds of interesting data out of Oklahoma, even though that's kind of conflicting with experience that we have down in Texas, and that we see what we know. We have a position paper by KGS on the issue that looks pretty good for us in Kentucky. And it may be that we do nothing more than to recognize that it's an issue, to ask the agency, ask Kim's group to work on whether or not there is enough evidence that we should be concerned to ask Rudy as president to put together best practices to investigate whether or not the presence of any suspect faults or microfaults might require some type of additional thought, if not action. I think that communicates to the public that we're not sticking our head in the sand, even though we may have more data.
Well, go ahead.
I just want to remind
Microphone, Bill.
Reggie that the Kentucky does not have primacy, and Kentucky Division of Oil and Gas at this point couldn't do anything about a properly permitted UIC Class 2 well if it wanted to. Having said that, I hear what you're saying, and that is address the issue. I have pushed to address issues that we can put our arms around, wrestle to the ground, and stand back up and have done something. Now, I'm not saying a discussion of seismicity, and I have to correct you, it's not a fracking well, it's a disposal well that has been linked to seismicity.
And that's what I wanted to give me just a second here, Tom.
No, go ahead.
I just want to point this out. In the minds of the public, they're the same. I know they're different. A fracking well is different than a disposal well. I know that the problems are in the disposal well and probably the rate of disposal. That's what seems to come out. There is one study up in Ohio that involves a fracking well. And if none of that bears out and it's all disposal wells, terrific. We come out, we've studied it, we've got the data, we've got the science behind it. We're okay in the state of Kentucky in the location of our fracking well, so don't be concerned when we come and knock on your door and want to put one in. Now, you might have a concern about a regulated underground injection well, but that's a second issue. We can maturely address it.
No, I think both comments were well taken. I think what we have identified water and wastewater as an issue for this round of discussions. I don't view us as running away from the issue. We've been monitoring the development of the literature. I agree with Bill, of the literature I've seen so far, other than the one study in Ohio, suggests that it is not the induced seismicity, that unintentionally induced seismicity, I might say, is because you're intending to fracture in the producing zone. But the unintended consequences are a matter of the downhole disposal of wastewaters in some cases. Whether it be lubricating pre-existing faults or causing displacement. We've been monitoring that, but I agree with Bill that it is right now, if there is a need for additional data to be collected as part of a disposal well process, under the UIC program, there is a mechanism to do that. And so it is a conversation to be had with Region 4 regarding when and if additional information is necessary, given the formations that are being produced here and given the downhole disposal formations that you would be disposing of here in the state. And I think that the drilling of the array in order to gather that additional information is a critical component of that. Is there a problem that we would need to upgrade your pre-drilling geologic data to identify? So I don't view us as running from the issue. I think it is, seismicity is one of those issues that is intertwined with wastewater management. But I agree with Bill, it is one over which we don't have a significant amount of regulatory control at this point in time. However, if the program, which gets back to the resource issues, if the program is delegated, we will then have to squarely deal with it, and we'll also need a significant increase in the workforce to manage that program. So,
I introduce my new moderate friend, Tom FitzGerald.
We got time for one more question, Stephen.
I'm like fine. I'm just aging a little.
Yep.
Thanks. Maybe I was able to stir it up or set the stage a little bit. I wanted to clarify something in there that Reggie was saying. I was trying to use the term mountaintop removal and coal mining as an analogy because I think it's become the lightning rod, and many of the opponents are using it as an equivalent to fracking. And I think we're seeing the same people protesting.
It's not fair. It's not fair to do that.
But I think there's a perception out there that that's true. I think there is a lot to that. We'll disagree on that one. Maybe, and also it mentioned we need to try to work with more environmental groups. I was trying to give Tom a left-handed compliment there in that respect. But, anyway, maybe a question here. We have seen bans, New York State, local communities. And I think we may see some communities in Kentucky try to do that.
Yep.
We've seen a lot of activity in Korea and about that, especially on the natural gas liquid side. Any comments on that as far as Kentucky goes?
I will start that. At the board of directors meeting of KOGA yesterday, I took an informal poll of the board members and their companies if anyone had ever drilled a well in Madison County. Now, there are a limited number of wells that have been drilled in Madison County, but not one member of the board of directors nor a company that they work for has ever drilled a well in Madison County. The board did authorize the Governmental Affairs Committee to move forward with an endeavor to commence a county education in Madison County of business leaders, politicians, and the like, on what drilling and fracking represent. So we're going to move forward with that, and hopefully we'll have a discussion based on facts rather than convenient facts. We've been to Madison County, as you pointed out, on EKU radio, and there's a different set of facts floating around Madison County that I'm familiar with. So we have our work cut out, I believe, in Madison County.
It's a problem of not having a level playing field. Until you have a preemption by the federal government on a program that allows you to move forward in the same way in each state, you're going to be fighting these battles, some which need to be fought and some which don't need to be fought. It's the unfortunate consequence, as Tom said, of the 2005 Energy Security Act, where in pulling the law away from a national regulatory body, deposits it in the states that may or may not be able to handle it, and even worse, allows small communities that certainly don't have the expertise to even address it to get involved in the game. And that seems to me not to be a very wise way for you all to do your business.
Steve, your point your question is well taken. Back, I think it was 2003, in response to the Letcher County Fiscal Court's efforts to pass an ordinance regulating gathering lines, because there was no effective regulation of them at the time, the Oil and Gas Association convinced the General Assembly that all counties should be preempted, except for zoning and planning. Right, that you could, through zoning and planning, regulate, the any aspect of the oil and gas industry, but otherwise everything from the exploration through the transmission of oil and gas is not within the power of a county's to regulate, other than zoning and planning. The frustration that I had over the years subsequent to that was that the corresponding mandate that the state developed that comprehensive set of regulations had not been implemented for various reasons. One of them was we did the stronger review, which was a collaborative review to try to identify what needed to be fixed in terms of waste management. But for a number of reasons, the effort had not produced fruit up until this past year. And that's why I was very proud to work with KOGA. Obviously, there are issues that we will not agree on. Right? We will not agree that non-utilities should have the power of eminent domain. And that's something that we're up in front of the state